Honorable Governor of Karnataka, Vajubhai Balaji, Honorable Chief Minister of Karnataka, Siddaramayya ji, Honorable Minister of Law, Government of Karnataka, Jayachandra ji, Shri Jitendra Sharma, President of the Indian Association of Lawyers, Shri P.P. Rao, who needs no introduction to any audience, my friend from Rajya Sabha, Shri D. Raja, distinguished members of the legal fraternity, ladies and gentlemen. Thank you for inviting me to a conclave of lawyers on a subject very much in their domain, but of relevance to every citizen. The makers of our Constitution were well aware of the glaring social inequalities that existed in Indian society. They understood the need to provide a form of justice which would fulfill the expectations of the freedom movement. As Jawaharlal Nehru put it before the Constituent Assembly, and I quote him, "The first work of this assembly is to make India independent by a new constitution through which starving people will get complete meal and clothes, and each Indian will get the best option that he can progress himself in." End of quote. The result of this exercise is reflected in its totality in the preamble of the Constitution. It sought to attain justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and promotion of fraternity, assuring the dignity of the individual and the unity and integrity of the nation. According to Granville Austin, the Indian Constitution is first and foremost a social document. The commitments to social change are contained in Part 3 as fundamental rights and in Part 4 as directive principles of state policy, or what he calls the conscience of the Constitution. In Part 3, the Constitution in no unmistakable terms declares the great rights and freedoms which the people of India intended to secure to all citizens, and in certain aspects, certain instances to both citizens and non-citizens, casting an onerous duty upon the state not to violate these rights. Part 4 of the Constitution providing juridically non-enforceable obligations on the state in the form of the directive principles of state policy. The juridical implications of this were spelled out by the Supreme Court of India in Minerva Mills versus the Union of India, where it held that there is no doubt that though the courts have always attached very great importance to the preservation of human liberties, no less importance has been attached to some of the directive principles of state policy enunciated in Part 4. The core of the commitment to the social revolution lies in Part 3 and 4, end of quote. The court added that rights in Part 3 are not an end in themselves, but are the means to an end, and the end is specified in Part 4. Together, the two realize the idea of justice which the Indian state seeks to secure to all its citizens. The judiciary is the guardian of the Constitution. Its role as the protector of civil rights has reposed the faith of the people in it. The Supreme Court has given a dynamic shape to the concept of social justice. In Calcutta Electric Construction Company Limited versus S.C. Bose, the Supreme Court held that the right to social and economic justice is a fundamental right. And Mr. Justice K. Ramaswamy amplified that concept in Consumer Education Research Center versus the Union of India, and I quote the judgment: "The Preamble and Article 38 of the Constitution, the supreme law, envisions social justice as its arch to ensure life to be meaningful and livable with human dignity. Social justice, equality, and dignity of persons are cornerstones of social democracy. The concept of social justice, which the Constitution of India engrafted, consists of diverse principles essential for the orderly growth and development of the personality of every citizen. Social justice is a dynamic device to mitigate the sufferings of the poor, the weak, Dalits, tribals, and deprived sections of the society, and to elevate them to the level of equality, to live a life with dignity of person. In other words, the sum of social justice is to attain, I beg your pardon, in other words, the aim of social justice is to attain substantial degree of social, economic, and political equality, which is the legitimate expectation." End of quote. The Supreme Court has expanded the envelope of social justice by adjudicating on diverse social matters concerning education, livelihood, gender, and environment. In Mohani Jain versus State of Karnataka, as well as in Unikrishnan versus the State of Andhra Pradesh, the court held that a man without education was no better than an animal, and held that the right to education was an essential ingredient for a dignified and meaningful life. In rural litigation, Entitlement Kendra versus the State of Uttar Pradesh, as well as in MC Mehta versus the Union of India, the court held that the right to life includes right to live in a clean and healthy environment. In Bandhua Mukti Morcha versus the Union of India, the court, while decrying the practice of bonded labor, held that right to life under Article 21 means the right to live with dignity. In Vishakha versus the State of Rajasthan, it held that sexual harassment of women at workplace is a denial of both her right to live and personal liberty. Personal liberty under Article 21, as well as amounted to discrimination on the basis of sex and violated the right to equality guaranteed under Articles 14 and 15. In Paschim Banga Khet Mazdoor Samiti versus the State of West Bengal, the court deemed that the failure on the part of the government hospital to provide timely medical treatment to a person in need of such treatment is a violation of his right under Article 21. One of the more illustrative sectors where the judiciary has given practical shape to social justice is in the progressive interpretation of the constitutional provisions in allowing affirmative government action. In Sadhuram versus Pulin, the court ruled that as between two others, the court would lean in favor of a weaker section of the society. In Indrashani versus the Union of India, it declared 27% reservation legal for socially and economically backward classes of the society under central services. At the same time, the court also tried to achieve a reasonable balance between distribution of benefits and distributive justice. in M.R. Balaji versus the state of Mysore, it held that for the object of compensatory justice, limits of reservation should not be more than 50%. The Supreme Court has expanded the concept of justice in the economic domain, making it an instrument of removal of socio-economic disparities and inequalities. In J.K. Cotton Spinning and Weaving Mills versus the state of Uttar Pradesh and others, it pointed out that in industrial matters, doctrinaire and abstract notions of social justice are to be avoided, and realistic and pragmatic notions applied so as to find a solution between the employer and the employees which is just and fair. Yet, the best intentioned judicial interventions and activisms on social issues has its own limits. In December 2014, the then Chief Justice of the Supreme Court constituted a special two-judge social justice bench to hear cases concerning socially marginalized groups. Diverse views were expressed about its functioning, and the experiment was shelved after a year. Where then, ladies and gentlemen, do we stand on the ladder of equity? This is a question that citizens of the Republic can ask the state after 70 years of legislating welfare laws and adjudicating measures to deliver social justice. The ground reality is dismal. Allow me to mention 7 of these. 1. The Human Development Report 2015 places India 130th in the Human Development Index amongst 188 countries. 2. Data culled from our National Human Rights Commission indicates that in the year 2012, 37% of Dalits lived below the poverty line, 54% were undernourished, 83 per 1,000 children born in a Dalit household died before their first birth, and 45% remained illiterate. Data also shows that Dalits are prevented from entering the police station in 28% of Indian villages, that Dalit children have been made to sit separately while eating in 39% government schools, and Dalits do not get mail delivered to their homes in 24% of villages. 3. Answering a question in the Rajya Sabha on the 10th of March 2016, the Minister of Human Resource Development said that in the year 2014, a little over 6 million children remained out of school. Of these, a massive 4.6 million, or 75%, belonged to the scheduled castes, scheduled tribes, and other religious minorities. 4. In regard to children of the largest religious community, the 2006 Sachar Committee report had observed that only 17% of them above the age of 17 were found to have completed matriculation as compared to the general average of 26%. Another report in the year 2013 found that the level of matriculation education amongst Muslims, both in rural and urban areas, is lower than even SCs and STs. This is also evident in higher education. 5. Despite all the governmental and society efforts, the overall literacy rate in the census recorded in the census 2011 was 73%, with female literacy at a dismal 64.8%. 6. A recent report by the wealth research firm New World Wealth ranked India as the 12th most inequitable economy in the world, with 45% of the wealth controlled by millionaires. Similarly, a report published by the financial agency Credit Suisse showed that almost half of India's total wealth was in the hands of the richest 1%, while the top 10% controlled about 74% of it. The poorest 30, meanwhile, had just 1.4% of the total wealth. And 7th, despite significant social and economic transformation, caste hierarchies continue to remain deeply entrenched, and caste relations often result in violent outcomes. According to a 2010 report by the National Human Rights Commission on the prevention of atrocities against scheduled castes, a crime is committed against a Dalit every 18 minutes. The sociologist Professor T.K. Uman identifies 9 categories of people who, in his investigation, are deemed socially and or politically and or economically excluded in varying degrees in contemporary India. These are Dalits, Adivasis, OBCs, cultural minorities, both religious and linguistic, women, refugees, foreigners, outsiders, people from Northeast India, the poor and the disabled. He concludes that while the principal agency to create and administer rights is the state, and while independent India's penchant for passing legislation is proverbial, but its incorrigible incapacity to implement them is abysmal. 2 other eminent scholars of socio-economic development in modern India have similarly noted that the societal reach of economic progress in India has been remarkably limited, adding that the agenda for political, economic, and social democracy remains unfinished because of continued disparity between the lives of the privileged and the rest, and because of persistent ineptitude and unaccountability in the way the economy and society are organized. It is thus evident that democratic mobilization, while it has produced an intense struggle for power, has not delivered millions of citizens from abject dictates of poverty. Thus, the de jure we, the people of India, in the first line of the preamble of the Constitution, is in reality a fragmented we divided by yawning gaps that remain to be bridged. Friends, being limited to an examination of the litigation and the judicial activity is one aspect of the matter. There are a number of reasons why attempts to litigate economic, social, and cultural rights may not result in judicial enforcement, and why, even if enforcement is achieved in formal terms, this may not necessarily protect or fulfill the right in practice. Even when compliance is secured in terms of individuals, this may be insignificant or even detrimental to the realization of the right from a societal perspective. The requirement thus is of a broad societal rather than a just political perspective. While not dismissing a constructive role for the courts in the enforcement of economic, social, and cultural rights, it is crucial to investigate carefully who benefits from the court. Who benefits from the court enforcement and under what circumstances judicial enforcement is likely to advance the broader realization of the rights and benefits those whose rights are most at risk. Experience shows that in the final analysis, those claiming social justice have to resort to the course of action suggested by Bhimrao Ambedkar to his followers many years before independence. And I quote him, "My final word of advice to you are educate, agitate, and organize, and have faith in yourself and never lose hope." Jai Hind.